SJC-11607, SORB number 34186, the Sex Offender Registry Board.
Ms. Zielinski, whenever you're ready.
Good morning, Your Honors. Jennifer Zelnowski, representing the Sex Offender Registry Board. It's the Board's position that the Superior Court made 2 errors in this case, and thus the plaintiff should be required to register as a sex offender based on his offenses committed while he was in the military. The legislature explicitly included military sex offenders in the Massachusetts registration law.
Could I just ask you a factual question? Is it the case that the board, in finding that he should register, relied on the conviction, I hope I'm going to get this right, is it Article 13? In other words, not the conduct unbecoming, but the other one?
Article 134.
134,
Right.
right.
The offender in this case was, he had 2 separate sets, if you will. One is Article 134. That's the one that we're arguing requires him to register.
Okay, so we're just, the conduct unbecoming, one, is that 133?
The 133,
Yeah,
yes.
that one's not on the
That's not what
table.
triggers the registration in this case. And,
You know, I looked, we have this elements-based test,
yes.
and I looked through the record, and I couldn't find anybody, either in 2002 or 2010, when the hearing examiner was making decisions in this case, that did anything more than point to Massachusetts statutes and say, well, they're the equivalent. But there was no elements-based analysis done at any point, and I don't see it in the briefs either. How are the federal statutes, assuming that it's Article 134, assuming that we go to the case law in the military world, that I forget the name of the case, but it's certainly clear that the Fossler establishes that to establish a violation of Article 134, the government has to prove beyond a reasonable doubt that the conduct satisfied at least one of 3 listed criteria, and one which is that it's a crime or offense not capital, and that they have to include a terminal event, which would in this case be the 3rd clause.
Yes.
So if you're looking to the federal offenses that are in the specification, how do we know, based on any analysis before us, that the elements in the federal offenses are the same as in the statutes that have been suggested in Massachusetts to be the ones that are comparable?
Well, Your Honor, I think, are you perhaps looking for some sort of lengthy, detailed checklist comparison by the hearing examiner? Because I think when the hearing examiner looked at the specifications as they're identified in the sentencing record, which appears at the Record Appendix 54, small a, the Air Force lists out the 3 specifications, and within those specifications are the elements of the federal offense, the federal law, the United States Code. And
Is that what those are, the elements? Or
That's what those are.
Just a description of a paraphrasing of what the statute prohibits?
I would argue that those would be the elements, the necessary elements to
Case
prove
law?
the offense.
Is there any case law that sets out what the elements of the offenses are?
I suppose there is, Your Honor, but I think when you specifically look at the elements that are laid out in the statute from the United States Code
Isn't that supposed to be part of what's done? If you're saying it's a like violation, is in fact to compare the elements to see if they match up? When our law says that elements are the same or nearly the same as an offense requiring registration in Massachusetts, and where the proof necessary for out-of-state convictions would also warrant a conviction of a Massachusetts offense. There's a lining up of the elements that has to be done, and I'm just saying I don't see it any place in the briefing.
And I think that although the hearing examiner may not have written out some specific finding that you're looking for, Your Honor, I think that they both make the conclusion that, especially in the 2010 decision, but they both make the conclusion that elements from the offenses are sufficiently similar. And when you're looking at the the federal offense of the knowingly transporting or shipping interstate commerce, the visual depictions of one or more minors under the age of 18 engaging in sexually explicit conduct, which was his first specification, and that's 18 U.S.C. Section 2252A12. The hearing examiners found that that was the elemental equivalent of the dissemination of visual material of a child in a state of nudity.
But I mean, where's the analysis of it so that we know that that's right?
I don't know that there's any requirement that they make a detailed analysis, Your Honor. I think that he can make the conclusion that by looking at this statute and the elements that are contained within that statute, that it is sufficiently similar to the state statute such that that conduct would be a conviction if it were committed in Massachusetts.
I take it that the petitioner here, or what should I call it? This is Sorb versus Sorb, sort of interesting. The plaintiff here is not contesting that, right? Not contesting that if you look at the elements of the underlying specifications, that those would be different, significantly different than the elements of offenses here.
Correct, Your Honor. That doesn't seem to be an issue that was raised. It's the issue that was
What
raised.
are the elements? Is it the element of 134 in general or the element of the underlying specification?
The argument that the petitioner raised at the Superior Court is more along the lines of Article 134 generally doesn't contain elements that would be the like violation of a mass offense. But
You mean the actual statement of the article in the code?
the actual statement of the article in the code. It's a little more, the way the board perceives it, it's a little more a generalized argument that more along the lines of simply because it's an Article 134 and it's not specifically knowingly transporting those types of pictures and that's not the title of the crime, that somehow that makes a difference because his conviction stands as being an Article 134 conviction. And the board's position is under Article 134, the elements under the specifications are adopted by that Article 134.
And that's, I guess, my question, since I know almost nothing about the Code of Military Justice.
I didn't know much until this case, Your Honor.
Is it possible for a military court to find somebody guilty of 134 if they find that the underlying conduct is abhorrent, but without necessarily finding that it would be a violation of the federal specified statute?
That would be possible, Your Honor, as was briefed by both parties in this case. There's 3 clauses under Article 134, and this is where it gets a little confusing when you're comparing it. But the first clause talks about service that's a disorder or a neglect clause, and that's an element of Clause 1. We don't have that here. We don't have an element of that. We don't have any evidence that that's what he pled to. The second clause is this discrediting conduct to the military service, and that's Clause 2. The only clause that this one fits into is Clause 3, which specifically talks about a violation of the laws of the United States. And when you look at then his sentencing report, those are the violations that he committed. So while in a hypothetical, there could be somebody who was convicted of similar or engaged in similar conduct, but doesn't get convicted under Clause 3, you wouldn't see necessarily the listing out of all the elements of the crime. You wouldn't see the reference to the violation in the same way as you do in the record in this case.
Well, why is it clearly not discrediting of the military? Lord, in Okinawa, there are many cases of popular unhappiness with the conduct of the military involving sexual abuse of natives.
There are cases, Your Honor, I believe Fossler is one of them. I think Medina, that the board cites, is another one. There's a recent case that came out called Merritt. They talk about how there's this additional element that needs to be part of the crime, and that's where the Clause 1s and 2s are, and that's that type of crime. That it may be conduct that is abhorrent or conduct that is discrediting to the military, but it doesn't get convicted as a violation of a U.S. law. And that's where the difference is in this case. We know he was convicted of that. That's what he pled guilty to on his sentencing sheet, are violations of the U.S. statute. The military can convict under Clauses 1 and 2 of conduct that may or may not violate the U.S. laws, but only under Clause 3 can you get a violation of the U.S. statute.
Fossler wasn't decided until 2011, and it wasn't really until Fossler that the terminal element has to be set for, the terminal element, either 1, 2, or 3, has to be set forth in the charge and the and specifications. This man was convicted in 1999, and the manual for courts-martial that was extant at the time would not have reflected that requirement. So how do we know that that was the case here?
Well,
Was there a plea colloquy?
Well, Your Honor, what we have in the record is the reference that I made to the sentencing, the court-martial report, in which it indicates that he pled guilty and there was a guilty finding to each of the 3 specifications. It's in the record.
And he also pled to a whole bunch of other things under Article 133.
He did plead to a whole bunch of other things, but those ones, when you look at the language of those, you'll see that they don't mention the specific U.S. code statute that he was pleading guilty to. So that's part of the reason why those are taken out of the analysis here.
But did the prosecutor stand up at the military tribunal and recite certain facts, and the defendant acknowledged committing those facts?
Well, Your Honor, unfortunately, the record isn't particularly clear on that, but the presumption would be yes. When you look at some of the other cases that are cited, they talk about plea colloquies in a very similar way that it happens in civilian court, and they would go through each of these. And again, I reference that in this particular case, there certainly is an extensive investigation record that tells you, and he would have been notified of that. And then at the sentencing form that we have indicates separately under each of the specifications that he entered a guilty plea and he was found guilty, and those identify out the elements of the crime. Unfortunately, we don't have a copy of a plea colloquy that would go through the specific details of the case. It's just not part of the record.
Do you know if the manual for courts-martial extant at the time of the 1999 pleas included provisions for plea colloquies?
I don't, Your Honor. I would have to review that. It's not something that I looked into. I would imagine that it would have, because of just the way that the military courts work generally. Similar to a civilian court, they are military offenders are entitled to have a statement of charges read to them as part of their arraignment and as part of their conviction process. And as I said, I think in the majority of cases that I've looked at where there is a plea, they discuss, and specifically in, I think it's the Medina case where they talk about, very specifically about the plea colloquy and why, and there's another case that plaintiff relies on, I think it's SAP, and they talk about it in that case too, in which that particular offender actually pled to the additional element of the discrediting conduct, which is Clause 2. And part of the argument in that case was that government or the military was sort of trying to pull that back. They didn't want that part of the charge in there, but the judge made the error and he pled to it, so it's ultimately part of it.
If a person is in the military and commits a sexual crime, is there any conviction other than 134 or 133?
There are 4 other types of crimes, Your Honor. Rapes and sexual assaults are delineated separately. It's Article 120.
120.
120. So those types of crimes, Your Honor, would be convicted separately, and that's where the Article 134 comes in. It specifically fills that gap of any type of conduct that would be criminal in a violation of a U.S. federal law. That's where Article 134 fills in. And recently, the military amended their statutes to be more detailed in their Article 120 offenses as well. They prior to were simply rape and sexual assault, and they've now delineated them out a little bit more as well. I think just showing that this is something that the military itself is trying to clarify out for civilian courts.
Let me ask you this. If this were on Article 133, conduct unbecoming, and the conduct was described, not in reference to any federal statutes, but just the underlying conduct, and he pled guilty to conduct unbecoming, would the argument be the same, or would you have a bigger problem?
The board would have a bigger problem on that fact pattern, Your Honor. I think part of that has to do with the way Article 133s are charged. The purpose of them isn't the same, and it is really more towards the unbecoming conduct that...
So we wouldn't look at the underlying conduct in that case that supported the charge of unbecoming.
Right. And I think that the Article 133 type offenses that you see in this case and you see in other cases, those would be ones that I think you would run into the problems that this court has raised before on these out-of-state issues, and that the only way you could get there is to look at the underlying facts and scenarios, and that's obviously prohibited, and you wouldn't have the
Because it's not-
same...
It doesn't have the elements-based.
It doesn't have the elements base, nor do you have reference to the specific statute. And I think in this particular case, that's the part that really triggers this offender's registration, is that we know he pled guilty to this conduct that is identified in each of these U.S. statutes. If there are no further questions, the board will rest on its memo for the remaining arguments.
May it please the court, John Percelli for the appellee. I expect to be brief. I believe this is a simple issue, frankly. The plaintiff appellee, and I'm going to call him Doe, was convicted of a single charge under Article 133. I know that we're not focusing on Article 133 necessarily, and a single charge under Article 134, both of the Uniform Code of Military Justice. And the general court-martial order, which is part of the record, indicates charge 1, Article 134, plead guilty, finding guilty. Charge 2, Article 133, plead guilty, finding guilty. And that's it. That's the general court-martial order. Now, Article 134, it's called, in the UCMJ, it's called the general provision, but it's also referred to more colloquially as the catch-all provision. It allows military authorities to punish a wide variety of conduct, some of which would not even be criminal.
But certainly some of which is, and the terminal elements include a third, which is a crime or offense not capital. And isn't that what his courts-martial, Article 134, included?
Not necessarily, Judge, and I think you questioned appellant on this issue. We can possibly assume that he was convicted under the third clause, but we don't know. There's no indication at all in the specifications.
Well, let me ask you then, do you have, you didn't make the argument that if you're incorrect about this, if we conclude he was convicted under Clause 3, and that the cases out of the U.S. Courts of Appeals for the Armed Forces, as they explain this, that a Clause 3 offense incorporates the elements of the federal offense in question, and that the evidence has to establish every element of the crime as required by applicable law, that some Clause 3 offenses are or can be like violations for purposes of the SORB statute. Do you challenge the conclusion, I guess, if we were to get there, that the elements of those specified federal offenses are like violations of the comparable Massachusetts statutes?
No, if you get there, no, I don't. I don't
Okay.
challenge that issue.
Okay.
So as I was saying, Article 134 is this catch-all provision, and I think it's extremely wide-ranging in its reach. All you have to do is read Article 134.
But didn't he, in the plea, didn't he plead specifically to the specifications?
He pled to Article 134.
But I mean,
Any service member in a court-martial proceeding is subject to the Uniform Code of Military Justice. It's not an Article 3 court. So he's subject to the Uniform Code of Military Justice. He's not subject to any civilian law. Civilian law may be used as this, we've been talking about specifications. It may be used as what I refer to in my brief is it's akin to a bill of particulars. It's a procedural mechanism, but the service member pleads to, if he does plead, he pleads to the article in the UCMJ, nothing else.
But didn't the article contain verbiage to the fact that he was alleged to have violated United States Code Title something, Section something?
No, it didn't. The specifications indicated that. The article is the article.
I'm a little confused about your couching this as though we're just sort of something general that it's, and I don't understand this area, so you'll have to help me. I gathered that there is something called the Assimilative Crimes Act, which has a little bit more teeth to it, that basically says that if you're going to charge somebody with something under 134 third clause that is actually an offense in the civilian world, then under that act, you actually you incorporate it as assimilated as part of the charge, and it's incorporated and you must specify. So it's not just, oh, it's like this, it's, you actually are assimilating the underlying crime, federal crime, that would be a crime if you were a civilian. You assimilate it into the military process, and then you must also specify, it's required. What's the point of all that specificity if it isn't really that you are bringing it in, assimilating it into the court-martial?
Your Honor, I believe the Federal Assimilative Crime Act is not applicable here. That's applicable
okay.
where a state law is being used to prosecute, where in a situation where someone's on, for instance, a military base where the state law may not be applicable.
Huh?
Now, in terms of assimilating, in terms of that word assimilating, it's an interesting word, and it's applicable here in the sense that if the court, and I rely on U.S. v. Brown, and I talk about that at some length in my brief, which is a 2003 case, 10th Circuit. The court in U.S. v. Brown said, yes, we understand that certain specifications for this person that we're looking at now, when he was convicted in a military court-martial, the specifications were assimilated into his Article 134 conviction. We understand that. But he was convicted by reason of the authority of Article 134, not by reason of authority of any civilian statutes. And in fact, Brown, the civilian statutes had to do with possession of child pornography, not unlike.
Well, if what you say
yeah.
is, if what you say is true, the Massachusetts statute that allows SORB to go through the registration process for somebody who was convicted in a military tribunal is absolutely meaningless.
It's not meaningless, Judge. Well, first of all, I think the court talked about Article 120, the most serious sexual offenses. For instance, rape of a child, aggravated sexual assault, etc.
Aren't those under federal
Those are
statutes?
those I would. I'm sorry.
Don't those incorporate federal statutes too?
Yeah.
No, those have
120?
elements in the UCMJ, specific elements in the UCMJ that could be theoretically could be compared to the elements of a similar like Massachusetts law.
So if we looked at Article 120, we wouldn't find a reference to a specification to a federal statute?
I don't believe so, Justice. I'm losing my train of thought here in regards to the.
Well, let me jump in then and ask a question. In your research, did you find any other courts that allow registration for a court-martial similar to what happened here?
I don't.
Well, what I'm trying to figure out is Justice Spina's question. Is this a meaningless statute if it's impossible to ever require somebody to register who is court-martialed under Article 134 and have other states encountered this problem, and how have they been resolved, if you've done that research?
I've done some, and I think the issue is that other states' sort of SORB guidelines can be quite different
I understand.
than they are in Massachusetts. So I can't fully answer that question, Justice, but just going back, whether it's meaningless, whether the Massachusetts like violation regulation is meaningless or would be meaningless, well, I guess my response is that's the state of the law.
Well, but Article 134, is it something like an indictment?
No, it's an article of the UCMJ. It's a specific article of the UCMJ.
But the
and
charge which lays out those specifications, is that like an indictment?
is a charge that lays out the specifications.
Well, this has, it has 3 specifications, I think, right?
In this particular case, it did. It doesn't have to.
But is there a document that lays those out for your client when he was first charged?
The general, what we have in the record, we don't have everything in the record regarding his court-martial conviction. What we have in a record is a general court-martial order, and it indicates Article 134, and I believe it has all the three specifications under Article 134. And clearly, they cite the applicable federal law for each of the specifications.
And when he
there's a-
pleaded guilty, wasn't he pleading guilty to the specifications?
No,
Yes, but
no,
on-
Justice.
If you look at Record Appendix 54, I think the reason for our asking these questions is that in addition to the Article 134, Charge 1, as to which there's a plea of guilty and a finding of guilty, if you look at each of the specifications, 1, 2, and 3, the plea says guilty, finding guilty as to each one of the specifications.
Right. But the charge,
Well-
Your Honor, was under Article 134. The charges, the specifications were not charges. The
Yes, but the
specification,
statute says sex offense is defined as da-da-da-da, or a like violation of the laws of another state or military tribunal. So why isn't this a like violation?
it's not a like violation because we're, in all of the prior like violation cases that have been decided by this court, you've compared conviction to conviction, essentially, or conviction rather to an applicable Massachusetts law that's alleged to be like the person's conviction in another, usually in another state. Here, the conviction, and I don't believe I'm being hyper-technical here, the conviction was under Article 134. As a service member, you cannot be convicted of a civilian law. You can only be convicted of an article of the UCMJ, and that's what this gentleman was.
But
And
in
I
order to
think
be convicted of that, the evidence has to establish every element of the crime that's specified.
Clearly, Your Honor, the elements of the specifications as the Brown Court indicated, are assimilated into the Article 134 conviction. But the conviction is by reason of the authority of, and I think it bears emphasizing this, by reason of the authority of the UCMJ. Here's my concern, frankly, that here's what I would see would be the result of this. As you've heard from my sister, there's three clauses of the UCMJ. Again, we're assuming, and that assumption could be wrong, that this is an article, this is a Clause 3 matter. Well, a Clause 2 doesn't have to cite any federal laws, doesn't have to cite
But here
specifications.
they did. The order of court-martial cited three specific federal statutes. The defendant pleaded guilty to violating those three specific federal statutes, and they were incorporated by reference in Article 134. Isn't that the structure of the military tribunal?
Again, he pled guilty to a violation of Article 134. He pled guilty to, and also to one violation of Article 133. Article 134 happened to have three specifications. Article 133 had 35 specifications.
Yeah, but the Article 134 specifications didn't say he was caught chewing bubble gum in public. He was caught in possession of material showing, I forget exactly what it was, knowingly possessing visual depictions of minors under the age of 18 engaged in sexually explicit conduct.
That's true, Judge. I acknowledge that. I concede that. But the point is that, again, and I'm going back to this, and I'll go back to this frequently if I have to, the conviction is under Article 134. It's by reason of the authority of the UCMJ. As a
rely on
service member,
Brown.
it's not under the reason of authority of any civilian court or any civilian
Then you
law.
rely on Brown, right?
I'm
Is that
sorry?
what you said? You relied on that Brown case?
I'm relying on
Right.
Brown.
And that Brown case relies on United States versus Almendarez, right?
It cites several different
Yeah,
cases.
that's where that particular thing comes from. And that says, when the federal measure of criminality is the crimes and offenses, not capital clause of 134, the clause through which the assimilative crimes offense is imported into military law, the specifications must set forth each element of the underlying offense. Otherwise, it's fatally defective. And there must be a point to that, right?
I'm sorry, Judge?
Must be a point to that assimilative clause law?
But
that it
Brown
has to-
goes, yes, but Brown goes back and says that we know they're assimilated. We agree it's assimilated, but the conviction is under Article 134. And that's not a technical, hyper-technical
But does our statute
Differentiation.
require a conviction to have been under a federal sex offense statute, or just that his offenses?
I'm sorry, Justice, I
Does-
didn't
does
get the
our-
beginning of
does
your,
our- Does our statute require, though, that his convictions have been under a federal sex offense statute? Or simply that the offenses are like the enumerated offenses in our sub-statute?
well, I think the statute requires a comparison of the conviction. What is the conviction?
So
And here's the-
Your view, as I get it, is that even if it was absolutely crystal clear that the judge found him guilty of a violation of 134 because the judge found him guilty of an underlying federal crime specified in the allegation, that would still not be enough? Because the conviction is for 134 and not for the underlying violation.
Well, the judge, he actually pled guilty in his court-martial. He pled guilty to Article 134. He pled guilty to a violation of Article 134. The specifications are simply procedural mechanisms to get to that Article 134 conviction.
If he had pled guilty to Article 120, that wouldn't be a problem?
A problem in the sense of a like violation?
A like violation?
Well, of course, depending on what, Article 120 includes a number of different sex offenses.
Rape.
But let's assume it was rape, for instance. There are elements in Article 120. So those elements, and I don't know, I haven't done that comparison, but those elements could be compared to the elements of the applicable Massachusetts law.
So it'd be-
With Article 134, at least under current law, they cannot be.
Is Article 134 limited to certain sexually related offenses, or could it be
Oh.
stealing a car?
It could be anything that's not in any of the other articles.
Not capital.
It could be something, right. It could be something that's not even criminal in the civilian world.
Thank you.